Hello, everyone, and welcome to Uncivil Law. For today's case, we have a First Amendment violation. A sheriff went to a teenager's home and demanded that they remove their Instagram post lest they be arrested because they didn't like what the Instagram post said. This is an ongoing case. In the case of Amyiah Kuhn versus the sheriff of Marquette County, Wisconsin. So we're going to be reading this complaint that was recently filed. We're going to be reading what the government is doing, and we're going to explain to them the First Amendment is a thing that continues to exist. So let's read on. The First Amendment protection of speech, especially online speech, is as vital as ever during the ongoing pandemic. It sure is. As our ability to talk in person is somewhat lessened, the alternative channels that we have for First Amendment communication become all the more important, yes. The unprecedented stay-at-home orders throughout the nation have made social media one of the few outlets people have to communicate with friends and family. Very much true, very sad for everyone. This case is about preserving the right to share our experiences with each other during this difficult time. Yeah, a high school student who had a scare with the pandemic posted about her experience on Instagram, and a few days later, a deputy sheriff showed up at her home and demanded that she remove her post or be cited for disorderly conduct, arrested, and jailed. Yeah, no, just none of those things. None of those things. Like disorderly conduct, you can just know, like without even reading the specific elements of the statute. The whole thing about disorderly conduct is right. It's creating some sort of intimate, immediate issue, like in the real world. Like you're creating a scene or you're creating a hostile environment, right? You're creating an environment in which bad things are about to happen, right? You yourself are being disorderly and just being like, drunkenly throwing your arms around or whatever, or you're inciting other people, or you're about to create some kind of problem, right? So whatever you're doing is creating some sort of real world problem right now that we got to fix right this second, right? So like this is what disorderly conduct is, right? You're behaving in a way that is not in keeping with the rest of people, and you're either a threat unto yourself or you're about to cause other people to become a threat. You're goading people on, that kind of thing, right? So I don't know that it's impossible, but it immediately strikes me as difficult to do disorderly conduct online because all the rationales for disorderly conduct that exist in the real world don't really apply to the online environment. There's no like scenario where you're creating a problem and like the people in your immediate physical surrounding are becoming increasingly threatened by what you're doing. What immediate physical surrounding, right? So the whole like rationale for disorderly conduct as it exists in the real world, like you are becoming a problem to the people who are immediately around you, doesn't really exist in the online world. So, I'm not sure it's necessarily possible to commit disorderly conduct online, and definitely not what we saw here, yeah. Between March the 7th and March the 15th, Amyiah went on a spring break trip to Disney World and Universal Studios in Florida with her high school band class. A popular trip, to be sure. Been there several times. Very exciting. While Amyiah and her class were in Florida, the country began shutting down due to the pandemic. Amyiah and others on this spring break trip returned on March the 15th, earlier than planned due to closures in Florida. The Ides of March have become truly a marker for this particular disease, yes. 4 or 5 days after she returned from Florida, Amyiah began feeling ill. Her symptoms included a fever and dry cough, symptoms consistent with the disease. On March the 22nd, 1 week after returning from Florida, Amyiah began having difficulty breathing, so her mother took her to the emergency room at Divine Savor Hospital in Portage, Wisconsin. The doctors there evaluated Amyiah and concluded that her symptoms matched those of COVID-19, but they could not test her due to criteria at the time. So yes, different health authorities have been going through different criteria, not for the least of reasons is that the amount of tests available has been somewhat limited, so they have different criteria for different people, and she did not fall within the guidelines at the time. So they didn't run a test, but they're like, well, we don't necessarily need a test to diagnose it. A test would be helpful, but we can take a note of your symptoms. And we're like, yeah, this seems to be all the markers of, a disease. There was a time and place when doctors didn't really have lab tests, so doctors had to diagnose things without lab tests, and sometimes they still do. So that was the situation here, right? They said, well, we can't really conduct a lab test, but you have all these symptoms. It's consistent with what's going on. So, yeah, you probably have this disease. So let's press on with, medical treatment. Okay. The discharge order, a true and accurate copy of which is attached as an exhibit, diagnosed Amyiah with acute upper respiratory infection unspecified. So it's like, we're not quite sure what you have. We know you have an upper respiratory infection. We're not exactly sure from what, but we'll tell you as much as we know. That's fine. The doctors also gave the Coons a work release form, a true and accurate copy of which is attached, specifying that Amyiah has symptoms consistent with COVID-19. So they have reason to believe that she has COVID-19. Not incidentally that it really matters in terms of her ability to speak, because, she would have an ability to speak anyway. But she, in fact, believed it to be true. So, to the extent that we're concerned about that, she believes it to be true, and to the best of our knowledge, it appears to be true. Fair. After she got home from the hospital, Amyiah posted a picture of herself from the spring break trip with the caption, "Hey guys, sorry I've been on a long break. I won't be back for a while longer due to me now having the virus. I don't want attention, it's just the truth. I'm now in self-quarantine and not allowed to leave my room and have had an inhaler since they said go home. Best of wishes, listeners, love you guys." Amyiah was self-quarantined in her home from March 22nd until March 25th. On March 25th, Amyiah's symptoms worsened, including significant difficulty breathing, so Miss Coon took her back to the emergency room at the hospital. While at the hospital in Madison, Mrs. Coon received a call from the principal of the high school on an unrelated matter. Mrs. Coon told the principal about Amyiah's situation, including that she had left a voicemail for the band teacher, and suggested that the school may wish to notify other parents with students on the spring break trip. The principal told Miss Coon that she would follow up with the band teacher, but the Coons never heard back from either the principal or teacher. Okay, so we have a parent who previously left a voicemail message for the band teacher, letting them know, hey, you might want to let other people know. And now we have the principal calling the mother for some unrelated matter. And she says, oh, by the way, just to let you know, we think that there's this problem with this, our child might have this disease. And so you might want to let other people know. So we have a parent telling the principal there's a problem. And, it's not like just the student saying it. Now it's the parent also saying it. So maybe you want to potentially rely on that to some degree, that maybe the parents telling you what they believe to be true, even if it's not true, they believe it to be true, and maybe you want to operate on that assumption. Might be a good idea. After she returned home, Amyiah posted again to Instagram, this time a picture of herself at the hospital with an oxygen mask on her face, which would be somewhat indicative of some kind of respiratory ailment of some variety, yes. The caption on the post read, "I'm finally home after being hospitalized for a day and a half. I'm still on breathing treatment, but I've beaten the virus. Stay home and be safe." A true and accurate copy of this picture is posted as an exhibit. The Coons do not have a screenshot of this Instagram post because Instagram deleted it in response, because Amyiah deleted it in response to the threat of arrest. So yeah, we don't have we don't have a copy of the post, but we do have a copy of the picture. Fair enough. During the evening of March the 27th, defendant, Patrol Sergeant Cameron Clump. So this is the Clumps. This is the Clumps who are acting. That's good news. All right, Mr. Clump, what do you have to teach us? Clump from the Marquette County Sheriff's Office came to the home. Amyiah answered the door, and Sergeant Clump said he needed to speak with the father. After Mr. Coon came outside, Sergeant Clump explained the school's superintendent had complained to defendant sheriff Joseph Conrath about one of Amyiah's Instagram posts. Okay, well, who cares? Amyiah has the right to use social media to express her thoughts and express concerns and to relate things that relate to her. So, the superintendent's concerns are super, super interesting, but what concern is it of the police? Who knows? Sergeant Clump stated that he had direct orders from the sheriff to demand that Amyiah delete this post, and if she did not, to cite Amyiah and or her parents for disorderly conduct and start taking people to jail. As I was saying earlier in the stream, this is probably not disorderly conduct. This is not what the statute had in mind. Sergeant Clump's incident report, a true and correct copy of which is attached, confirms the defense unlawful actions. It's always nice when the police's own documentation confirms what you're saying. That's always a bonus. The Clump report explains that the sheriff advised me he wished to respond to the residents and have the post removed from social media. Okay, well, you You've told us exactly what we're trying to prove. That's very helpful. The report also states that Klump advised Richard Kuhn that if they are not willing to take the post down, there would be the possibility of a county ordinance disorderly conduct. The report also states that Klump advised Richard Kuhn that if they were not willing to take the post down, that there would be the possibility of a county ordinance disorderly conduct or being arrested for disorderly conduct. So we're threatening people with arrest if they don't censor speech. And no one thought to themselves, hey, maybe this is something we should not be doing. Okay. Sergeant Klump stated that Sheriff Conrath wanted the post removed because there were no confirmed cases in the county at this time. Okay, well, no. Just because there are no confirmed cases is not the issue. She has reason to believe that she has the disease. It's been noted on her documentation that she may have the disease. So it wasn't confirmed in a lab test in that sense, but the doctors are saying, yeah, it probably is this. So it's like, that's certainly enough to rely on. Not that she needs it in the first place, but okay. So I don't know what the problem is. But neither Klump, nor Conrath, nor anyone from the school district had contacted Amyiah or the Coons to discuss the symptoms, or learn what doctors who had treated Amyiah had told the Coons, in that the Coons had notified both the principal and the band teacher about the symptoms. So, we told the school officials about this, but they never tried to contact us to, learn more. Apparently, what they did is decide to report it up the chain as being false, other than, just trying to, investigate it for some reason. Mr. Kuhn offered to show Sergeant Klump the documents they received from the doctors at the hospital, including the symptoms were consistent with COVID, but Sergeant Klump stated he was not there to gather information, heaven forbid, but to complete the orders. Super exciting. Out of fears that the sergeant would follow through on his threat to arrest and jail her or the parents, Amyiah agreed to delete the post. She showed Sergeant Klump her Instagram account on her proof that she removed it. So yeah, we basically got a fascist in the form of a authority with a police officer behaving in a fascist way. We got a fascist coming to the door and saying, delete this or else. And now we're peering over this child's shoulder to make sure that they actually delete it in compliance to our unlawful orders. So, these fascists can eat it as far as I'm concerned. After Sergeant Klump left, out of an abundance of caution and fear, Amyiah also deleted her first Instagram post, but not until saving a screenshot of it. Very good. Later that evening, the Coons discovered that earlier in the day, the Westfield District Administrator, Bob Meicher, had sent an update to families in the school district that included a statement about the post. The administrator's update stated that it was brought to my attention today that there was a rumor floating out there that one of our students contracted COVID while on a band trip to Florida 2 weeks ago. Let me assure you that there's no truth to this. Well, the doctors who have been treating her appear to disagree with you, Administrator, so I'm not sure what medical knowledge you're relying on, but the doctors say, this probably looks like it could be COVID, and you're saying, well, there's no truth to this. Well, other than the doctor saying that, yeah, it's probably true. So, there's that. This was a foolish means to get attention, and the source of the rumor has been addressed. Yes, it was. Very unlawfully, may I add. You are a dick, Administrator Meicher. This rumor has caught the attention of the Public Health Department. As it well should. They might have an interest in this too, yes, by maybe investigating it medically. So the fact that it got the attention of the Public Health Department isn't concerning. They may want to take note of this, and they may want to do some follow-up work. So the Public Health Department getting their interest, that was perfectly fine. The way they expressed their interest, much less so. She was involved in the putting a stop to this nonsense. I don't know who by she they mean. Presumably the head of the Public Health Department. So the Public Health Department is directly responsible for putting an end to this. That's good news. Not by investigating or anything, merely suppressing the tweet or Instagram post, whatever the proper nomenclature is for that. In times like this, the last thing we need is misinformation, which apparently you're the one delivering the misinformation. You're the one delivering the misinformation, so look in the mirror on that one. I asked her to prepare a short statement for the purpose of this update. I've pasted it below. Very exciting. So apparently we've got the sheriff, the administrator, and the Public Health Department, it seems, conspiring, not to investigate this in any way, not to ask follow-up questions. The Public Health Department could go to the hospital and be like, what's going on here? Maybe this is something we should take a note of and look into it, but no, not so much. None of these things. We're just going to say it's a girl who craves attention. A girl who creates attention by posting a picture of her in the hospital with an oxygen mask over her face. But she's doing it strictly for attention. I don't know that a hospital will admit you and put a mask over your face if you're trying to do it for the likes. I don't really see that happening. Sheriff Conrath and Sergeant Clump's threat to cite and arrest Amyiah for posting about her experience are especially troubling in light of the administrator's statements accusing Amyiah of not being truthful and engaging in a foolish means to get attention. Or, in the alternative, a not such foolish means to inform people. And even if it was a means to get attention, it's freedom of speech. She's allowed to do that. So, With threats of law enforcement looming over her threat, Amyiah has felt unable to respond on social media to the allegations. That's okay, Amyiah. I'll respond for you. I'll respond for you by calling the administrator a dick, and calling the school, and calling the principal a dick, and calling the sheriff a dick. They're all dicks. So I'll do it for you, no problem. And, other internet lawyers have been responding to this too, and rightfully so. So yeah, we've got your back. We are bringing attention to this travesty. So yeah. And she's afraid of returning to school for fear of what her classmates and teachers will think. Yeah, they think she's a liar, even though she apparently isn't. On April the 3rd, the undersigned counsel sent a letter to the sheriff on the Coon's behalf, explaining that these actions, and those of the sergeant, violated Amyiah's First Amendment rights. Yeah, and asking him to acknowledge the violation and provide written assurance that they did not violate the rights going forward. So counsel is doing probably what I would do in this place. We're trying to resolve this, simply. We don't necessarily have to go straight to a lawsuit. Let's see if we can resolve this informally, right? So I'm all about this. I'm all about this informal. I'd probably want to do this too. I'd send them a letter and be like, look, guys, we have this evidence. If things that happen, let's try to just resolve this before we go into court. But the county doesn't want to do that. They don't want to just eat it while they can. They want to press on. So they're going to spend lots of money to defend a case that's indefensible. Super great. Between April 6th and April 13th, the counsel for sheriff and plaintiff's counsel exchanged emails. So they're talking back and forth for several days, trying to resolve this informally. Again, I have no particular problem with this. This is fine. Let's see if we can resolve this informally. That's great. The sheriff, however, declined to acknowledge the First Amendment violation or to provide any assurance that the parents would not be cited, arrested, or jailed in the future for similar speech about the experience with COVID-19. Instead, the sheriff stated that Amyiah's speech was not protected by the First Amendment, but was equivalent of screaming fire in a crowded movie theater. No, that's not what that case means. That case talks about falsely doing it in a movie theater. And the whole point of it was that the statement would cause an imminent physical threat, right? If you did it falsely, people would start running for the exits, which might create a problem. People might trample each other, so it would cause actual real harm. But the whole point of it is that it's causing an immediate physical threat. Your words are inducing a panic that's going to cause an immediate problem. There's no analog here. First of all, the statement's true. So you can truthfully cry fire in a crowd theater, and if it's true, you probably should. That seems like a really good idea. And more to the point, there's no physical space issue here. So there's no immediate threat issue. So the analogy fails, both because it's true and because the physical proximity issue that is at the root of that case doesn't apply. So the whole thing is just completely wrong. No. Given the defendant's prior threats and the sheriff's unwillingness to acknowledge the First Amendment violation, that's okay. A court will do it for you in short order. Amyiah reasonably fears her social media is being monitored by the sheriff's office, and another deputy may show up at her door if she posts anything about the future and experience. That's okay, Amyiah. I got your back. I'll tag them on Instagram. I'll make a post about this and tag them on Instagram, and I'll tag everyone myself. It should be lots of fun. Yeah. Thus, we come to our violations. Violations of the First and 14th Amendment. The First Amendment guarantees through the 14th Amendment, yes, it does. Freedom of speech applies against the states. It's pretty well established. There's about a zillion cases saying that. The First Amendment prohibits government officials from subjecting an individual to retaliatory actions for engaging in free speech. It sure does. It sure does. You can't do that. Urel Gray gives me $2 in the chat saying you rock in this case is insane. I could not agree more. It's pretty insane. Freedom of speech is pretty well established. It's been established for 250 years, give or take. So there's that. This principle applies equally to law enforcement. Yes, law enforcement is in fact a government actor. So yes, it does. Officers may not cite, arrest, jail, or threaten individuals with any of the above for engaging in protected speech. Yeah, you can't arrest someone for engaging in protected speech, right? For retaliatory arrest claims in particular, the plaintiffs must show the absence of probable cause. And Amyiah's Instagram posts were unquestionably speech protected by the First Amendment. Yes, it certainly was. There's nothing that falls into a First Amendment exception. It's not fighting words. It's not creating an imminent threat of lawlessness. Which, by the way, one of the key words in that phrase is imminent threat of lawlessness. Like right now, it is legal to encourage people to break the law, as long as you're not saying like right this second. So like if you're saying to people, let's break the law, or people should in general break the law. If you're saying let us break the law, that might be conspiracy. But if you're saying to people, it would be a good idea for people in general to break this law, whatever it is. It would be good if people were to, break into stores and steal stuff or whatever. As long as there's not an imminent threat, then there's not a problem, right? So you can even say it would be good to break the law. So again, the imminence isn't there. The physical threat isn't there. So none of the First Amendment like guidelines that we use apply, even like colorably. So this whole thing is insane. There's also no question that defendant's threat of citation, arrest, and jail are sufficient deprivation to violate the First Amendment. Yeah, that'll work. A threat is certainly a workable thing. Threats to do something illegal are also themselves illegal. If I'm robbing you, that's illegal. If I'm threatening to rob you, it's also illegal because the underlying thing I'm threatening to do is illegal. So yeah, you can't threaten to do something that is illegal in and of itself. That doesn't work. The Supreme Court has long recognized a realistic threat is enough to chill First Amendment rights. They sure have. This is not new stuff. Amyiah's protected speech on Instagram was not only a motivating factor behind this threat, but it was the entire basis. So that's basically showing a causality issue, right? So it did this cause this? Why were the sheriffs doing this, right? So like you could get into like a mixed motive. You could get into like a purely lawful motives. You could get into like a mixed motives where there's some lawful and some unlawful, or purely unlawful motives, right? So I don't know what the fact pattern would be in the purely lawful example because it doesn't really apply here. But if the sheriff had come for purely lawful motives, purely lawful reasons, and demanded they do a purely lawful thing, like it's okay, right? Then there's this issue of mixed motives. What if they have mixed motives? What if they're asking you to do something that is something that's within their power to do, and there's a lawful motive for them to do it and also an unlawful motive to do it? What do you do in like a mixed motives case? And there's case law dealing with how to solve a mixed motives case, right? But they're pointing out this isn't even a mixed motives case. This is all the way the other end of the extreme. This is purely unlawful. Their only motive was to take this thing down, right? So it wasn't like a mixed motive, like they're asking them to do some illegal stuff and some legal stuff, or mixed purpose. This is pure illegal purpose. So we don't even have to get into the mixed motives question. Yep, makes sense to me. Amyiah's Instagram posts about her experience in the hospital were in no way violent, abusive, indecent, profane, boisterous, or unreasonably loud. I don't even know what some of those things mean in the context of speech online. How can speech online be violent, right? Like, and we're talking about public disorder, right? So we're talking about a public disturbance, right? So we're not even talking about speech. So we're going back to the ordinance dealing with public disorder, right? So public disorder, what would that be? Like violence. Okay, this person is, throwing punches. We're about to throw punches. Violent, right? Abusive, same kind of thing, right? Indecent. This person has, stripped completely bare in the middle of the club. That might work. Profane. If the person is being unduly, using unduly verbious profanities, that might be disturbing too, right? It's not like a stray thing. It's more like it's continuing ongoing and it's becoming disruptive because of how much it is. There's that. Boisterous. Maybe this is a person puffing themselves up or threatening, verbally. Or unreasonably loud. Again, if a person is like yelling at the top of their lungs in the middle of a Starbucks, that would be a good example. It's being unreasonably loud for the environment. So it's being disruptive. So none of these things apply in an online context. Like what's the online analogy? It doesn't really work. Yep. Even assuming arguendo, which means for the sake of argument, that the post somehow could fall within the catch-all of otherwise disorderly, which it doesn't, because we're not in a physical environment where these kinds of like things make sense. We're not inside a coffee shop where this person is throwing punches or about to throw punches. We're not inside the coffee shop where this person is yelling at the top of their lungs when everyone else is being quiet. We're not inside the coffee shop when this person is just spewing all kinds of profanities, even though like no one else is. We're not inside the coffee shop when this person is being completely boisterous and like threatening people and egging people on. We're not in an environment where this person is disrupting the physical environment everyone else is behaving in, right? We're not in an environment where this person is behaving in such a way as to disrupt the purpose for which everyone else came to the place. Everyone else came to the coffee shop to drink their coffee quietly, and you are now being completely antagonistic to everyone else. So you're behaving like an ass, and you're behaving so much like an ass that it becomes criminal, right? So we have rules to deal with this. Your immediate physical threat, your immediate physical disruption. How does any of this apply online? It doesn't. So the rationale for the real world doesn't apply to the online. Yeah. But even assuming it could fall within this otherwise catch-all phrase, the Supreme Court has held that disorderly conduct may not be applied to protected speech. Yeah, which, this falls well into that category. If we're looking to First Amendment exceptions, right? You're normally looking to some imminent lawlessness. You're looking to fighting words, which example would be boisterous, for example. That might be an example of, puffing yourself up and, really egging people on, fighting words. That kind of thing. You're looking to, basically you're looking to imminent threats of some kind of lawlessness, of some variety, and none of that's here. And otherwise, it's like, what is the First Amendment exception applies? Oh, there is none. Okay, well, therefore it's protected speech. Yeah, makes perfect sense to me. Defendant Sergeant Klump is responsible for this violation because he directly threatened Amyiah and her parents. And as the final policy-making authority for the sheriff's office, the sheriff's decision in this matter represents official policy for the purposes of Monell. So Monell deals with 1983 liability for supervisory authority. We've covered this many times and will again. But basically, long story short, right, we don't really believe in, all right, let me rephrase that. The courts don't really believe in vicarious liability for police officers. So as a general proposition, if a police officer is doing something that's violating someone's civil rights, right, as a general proposition, the police department as a whole or the supervisor is not responsible, right? We don't have vicarious liability. So to show 1983 responsibility to the superior, you have to show some action by them. And one of the ways you can do this is by showing some direct policy from them, right? So the direct policy in this case would be, hey, deputy, go forth and do this on my behalf. So yeah, it qualifies under Monell for superior liability. So yes, we can go after the sheriff because they made a direct order to do it. So this isn't like a rogue police officer who's doing it. It is doing it because of the direction of their supervisor. So we can hold both responsible. The deputy should have said no because it was not legal. But he went and did it, so he's responsible and the supervisor's responsible. Yeah, under Monell, works for me. Therefore, we'd like the following relief. A declaration the posts were protected, and the threats were violation of the rights. I'm good with that. I'll give you that. A declaration defendants may not cite or parents for disorderly conduct or other crimes for exercising free speech rights. Sure. I'd have to write this a little bit carefully to make sure that it's being written carefully, but I'll give you a statement to that effect, yes. An injunction prohibiting them from citing them for disorderly conduct, arresting them, or threatening for exercising First Amendment rights. Again, I just write it carefully, but sure. nominal damages, which usually means $1, and such other relief as the court deems proper. Fair enough. So that is the end of our current coverage of Amyiah Kuhn versus the Sheriff of Marquette County. In this case, we learned the Sheriff of Marquette County went to a teenager's home to demand that Instagram post be removed because reasons or something, even though it was true. And the teenager did it, and now the teenager's suing. And, we are bringing shame to the government for doing this because they're in violation of this person's rights. Not for the least of reasons, it was true, and they were trying to inform people as it. And, the government, had they want to, could have done some minor investigation to find that out. Like the parent had told the principal it was true, so they could have looked into it a little bit. The public health authority could have looked into it a little bit. That might have been good, but instead they want to suppress the speech. That's not going to work. So we will see how this case develops. That is our end of our current coverage of this case. Thank you so much for being part of the Uncivil Law family. I appreciate your continued support. If you haven't already done so, please subscribe to the channel, and you can also support us financially by clicking the applaud button below. Thank you so much for your contributions to our channel. It helps our work grow. Until later, cheers and goodbye.